So I just want to welcome our audience today with Professor Cass Sunstein. We're talking about law and Leviathan, redeeming the administrative state. My name is Martin Schuok, and I'm the head of the MCC Public Law Center. And it's an immense pleasure for us to host Professor Sunstein of Harvard, who's the author of Nudge and many books in constitutional, environmental, and administrative law. And he's one of the most cited legal scholars in the US. It's a real pleasure to have him with us. And today we're going to talk about a topic at the intersection of constitutional and administrative law. Like the title has suggested, Law and Leviathan, Redeeming the Administrative State. It is the title of a book that Professor Sunstein and Professor Adrian Vermeule, if I'm not mistaken, have co-authored. And without further ado, I want to give the floor to Professor Sunstein with this question, maybe. How does, if at all, law, more specifically constitutional and administrative law, transform into a sea monster-like being like the Leviathan, which gave the namesake for Hobbes's theory of social contract? And how did this Leviathan inspire the ideas in the book about the administrative state?
Thank you for that. And it's a pleasure and an honor also to get to speak with you today. So thank you so much for having me. There are two concepts, let's say, which are also realities. The first, as you say, is the administrative state. And take that as an apparatus that's protecting health, we hope, protecting the environment, protecting safety, protecting a range of social goods if it's working well. And sometimes we see it in real life, and sometimes we enjoy our lives more because of its operations, whether or not we see it. And the administrative state consists of human beings who have names, and they work for institutions that have names. So that's one concept that is also a reality. There's another concept, which is the rule of law. And this is sometimes thought to be a mysterious concept. We can think of it as a not mysterious concept that involves no retroactivity, that involves clarity and generality, that involves operation in the real world in the same way it works on the books, and that involves a capacity for fair notice for people and also constraint on the administrative state. So the basic idea is we have these two concepts and these two realities. And if you have an administrative state without the rule of law, you have a big problem for everything that human beings ought to care about. It's not good for the economy without fair notice and planning. Economic growth is very difficult to achieve. It's not good for freedom, whatever our conception of freedom. It's not good for fairness, and it's not good for human dignity. So we might think of human dignity, if we like, I'm happy to do this, as a foundational value that people in different nations and different religious traditions, different cultures care about. And the rule of law promotes human dignity. An administrative state without the rule of law is dangerous. Administrative state with the rule of law can be a great boon to human well-being.
Thank you very much. And I understand the fundamental values and how they are reflected in the concept of administrative state, or how they should be reflected in what we call the administrative state. But what is really the administrative state? How did it come to be? As I know, there are at least 4 periods that affected the development of this notion from the Enlightenment until the present day. So what were the most important, I could say, milestones or phases of this development? And once that we have clarified this evolution, I would like to also ask you, why does it need to be redeemed, as the title of the book suggests?
It's a great question. And in terms of the stages of the administrative state, one of the first, maybe the first, occurred when Adam and Eve ignored the injunction not to eat the apple, and then the apple was eaten, and they fell to the serpent's seduction and left Eden, and then they were living the human condition. And there had to be shortly thereafter an administrative state to produce peace, to produce abundance, and to produce justice that was needed early. In terms of human history, the administrative state really does, I'm being a little frivolous, but maybe not entirely frivolous there. The administrative state goes way back to way before the Enlightenment. You didn't need the Enlightenment to have an administrative state. Ancient Greece had one, Rome had one, cultures in China had an administrative state well before the Enlightenment. There are modern developments in the administrative state, its rise, and they are either to be celebrated or to be lamented. One I'll give that I would celebrate, which is the New Deal in my own country, and forgive my parochialism, the rise of the New Deal under President Franklin Delano Roosevelt, which gave rise to the Social Security Administration, the National Labor Relations Board, Federal Communications Commission in its modern form, the Federal Trade Commission in its modern form, and a bunch of departments or ministries that expanded at least what the administrative state was. I think that's something to be celebrated in my view, not only to be celebrated, it's a work in progress, but it's good that it happened. Then there was fascism around the same time, which created in Italy and in Germany a new kind of administrative state, both in volume and in activity. And Hitler's administrative state and Mussolini's administrative state were not controlled by the rule of law in the way that well-functioning administrative states are. So the 1920s and 30s and 40s were very important. Stalin's administrative state was not controlled by the rule of law, and that's not consistent with respect for human dignity.
Thank you very much. And since you talked about a well-functioning administrative state and what the requirements for this are, how does the concept of administrative state relate to the principle of rule of law? Because we've mentioned it already, and separation of powers. This latter one is an issue that is mostly pondered upon by originalists among the US scholars and constitutionalists, while the former is a more general concern also in Europe as well, usually going back to the lack of accountability, at least in the European debates that we have today. So if you could elaborate on this, I would be thankful.
Okay, it's a great question, so thank you for that. The rule of law, as I understand it, and I'm following here the very distinguished and recently deceased legal theorist Joseph Raz, is a very distinct idea. It doesn't mean democracy. I'm in favor of democracy, but it's not the same as the rule of law. It doesn't mean freedom of speech. I'm in favor of freedom of speech, but it doesn't mean the rule of law. It doesn't mean accountability, at least not accountability in the broad way that I would embrace it. The rule of law is a different idea from that. So let's think, shall we, about ways in which the rule of law might be violated. Suppose a law is enacted in 2022 and it's brought to bear against people for things they did in 2019. That would be a violation of the rule of law because it would be unfair retroactivity. Or suppose it's the case that a nation's leader operates without rules in place that constrain that leader. So the ruler makes up the law on Tuesday or Thursday or Sunday in accordance with the ruler's beliefs about what should happen. That could be a democracy or not. It could involve a lot of accountability or not. One thing it doesn't involve is the rule of law. You could have a ruler who has a lot of rules on the books, but who is in a position to ignore them and to do whatever that ruler wants. And the rules are a little like a movie in the cinema, but they don't have binding quality. That would be inconsistent with the rule of law. You could have an administrative state in Canada, let's say, which is limited by the prohibition on retroactivity, by rules that are on the books and that the leaders have to follow until they're changed, and that operates in real life the same way that it operates on paper. In Canada, and I hope that actually is Canada, I haven't actually described Canada, the rule of law is alive and well, and the administrative state is subject to it, whether it is trying to reduce poverty or to promote employment or to reduce climate change or to increase safety on the roads. Those activities by the administrative state could be controlled by the rule of law or not. And in Canada, as I've described it, it is controlled by the rule of law. You can think of a nation which might be at war with, this is not a political statement, a nation that might be at war with Ukraine right now. And let's just say that it's not at all clear, I'm putting this lightly, that that nation follows the rule of law.
Absolutely, thank you very much. Now, you are admittedly a proponent for a broad discretion for what we call the administrative state. It is also stated in the book as well. But what would be the argument of those skeptics you are most in disagreement with, and why? And also, along with this, if you could summarize the finer points of criticism against the administrative state, and also the reasons, maybe beyond what you have already talked about, why it is a good thing.
Okay, so thank you for that. Discretion in the administrative state, we have to say a few words about. So if the administrative state is told by, let's say, law, that you have to ensure that there aren't more than 15 parts per billion of particulate matter in the ambient air. The environmental authorities are told 15 parts per billion is the standard and you have to ensure compliance with it. Then the administrative officials have no discretion. They are sharply limited. Compare with that a law that says the administrative state shall do what is requisite to protect the public health with a margin of safety. Then the law would give the administrative authorities discretion. There's one question whether it's unconstitutional to give the administrative authorities that level of discretion. In my view, it isn't unconstitutional under the United States Constitution. I think it might be under the German Constitution. And the reason under the United States Constitution it isn't is that the law, as I've described it, has a principle in it requisite to protect the public health with an adequate margin of safety. It isn't a grant of open-ended discretion. So my view is that if there's a grant of open-ended discretion, there's a serious constitutional problem. If there's some discretion, there isn't a constitutional problem. Now, I would not describe myself as a proponent of discretion for the administrative state because the administrative state's so large. In some areas, discretion is a good idea. In some areas, it's not a very good idea. And whether it's a good idea depends on whether circumstances are changing rapidly. If they are, that's an argument for discretion because the administrative state can adjust more quickly. If it's an area that requires technical expertise If it does, there's an argument for discretion because the administrative state will know about details involving, let's say, silica, which is a carcinogen, but enacted legislators not so much. So I would say that the constitutional attack on the administrative state in the United States, I would not embrace, but how much discretion is too much discretion as a matter of policy would vary with context. In terms of concerns about the administrative state, they could be warranted depending on whether the administrative state is constrained by the rule of law, as described, and depending on how the administrative state performs. So let's identify 3 potential problems, and the people who worry about this, I celebrate their right to worry about this. Problem number 1 is liberty. Does the administrative state compromise liberty? If it's subject to the rule of law, it will compromise liberty less than if it were not, but it still could compromise liberty. So if you have an administrative state that is not respecting freedom of religion or freedom of speech, or that is not protecting people's privacy, then liberty is at risk. And people can differ over what the right description of liberty is, but on any description of liberty, it's possible that the administrative state is jeopardizing it. So take liberty as problem number 1, and the rule of law is really important to counteract that risk. It's not enough. We need some other things in the system. The second problem is human welfare, where it could be that the administrative state respects liberty, but it isn't making people safe. It isn't making people, isn't doing anything about the pandemic, or it isn't doing anything about clean air, or it's regulating so much that it's squelching economic growth and not helping the nation to prosper. So human welfare, needless to say, is very important, and the administrative state might be promoting it or not. If it respects the rule of law, it's probably more likely to promote it, but it's not a guarantee. I'm enthusiastic about cost-benefit analysis as a tool for deciding what the administrative state should do. And the reason is, if the benefits are high and the costs are low, then we're more likely to be promoting human welfare. So there's liberty, and then there's welfare, and then there's self-government. So different nations have different conceptions of self-government, and in some nations, self-government isn't a prized ideal. But I'll tell you a little story, if I might. I was in a nation a few years ago before COVID that is not a democracy. And at an informal get-together where we were talking off the record, some of the leaders of the nation said, democracy is terrible. And I said, what do you mean it's terrible? And they said, democracy is terrible. And I said, democracy is not terrible. It's a way that we can make sure our policies are helping people, because the people get to decide who are the leaders. And they said, democracy is terrible. And I said, why do you think it's terrible? And they said, a democracy makes it much harder to plan, because you can't use a long time horizon because the leaders might change. And I said, well, that can be an issue. That's true. But isn't it important to figure out what people want? And they said, their answer was, absolutely, we agree with that. We're not a democracy, but we're very focused on what people want. We are consulting people all the time to learn what people want. I found that interesting. I didn't find it a convincing justification, but I found it very interesting. And one reason it was interesting is, even in a nation that did not like democracy, the idea of some form of self-government was appealing as a way of learning whether people are struggling, or whether people are angry, or people are subject to crime or illness. So the idea of self-government, however we understand it, could be promoted by the administrative state if it has a degree of accountability. And this is to your point about accountability. It's not about the rule of law, but it's very important. And accountability can be a way of ensuring a form of freedom, not in individual life, but where the citizens have some say in the direction of their nation.
Absolutely, yes. And there's also a criticism going this way, though. I mean, how can the employees of administrative agencies, who are the worker bees of the administrative state, be held accountable? This is sometimes resounded as one of the harshest criticisms against administrative state. But I also thought about another point based on your insight. Judicial governance is also something that is focused on some term or some kind of self-government, trying to fulfill the wishes of the people. And we also find judicial governance to be very effective sometimes, obviously, but there are harsh critics for judicial governance as well. So in your opinion, which one's better, if I can ask you this way, judicial governance or the administrative state? Or is there a distinction between the two?
Okay, I'd want to, if I may, try to understand what's meant by these concepts. If judicial governance means that national policy with respect to road safety or food safety or occupational safety will be set by judges, that's a terrible idea. They don't have the background or the expertise. If judicial governance means that the judges will make sure that the people involved in food safety or road safety or clean air or occupational safety are acting consistently with the law, that wouldn't be judicial governance. It would be judicial protection of law, and that's good. So to have judges ensuring compliance with the law is important. To have judges making policy is dangerous. For the worker bees, as you described them, I've been privileged to work with them, and I would describe them as professional men and women who are, on average, in my own experience, honorable and terrific at their jobs. They are the day-to-day operators of the administrative state. And this is just my experience in the United States. They deserve to be celebrated and treated with respect. Some of them are lawyers who really understand their area of the law, probably better than anyone in the world. They might be policymakers who understand how to think about air pollution in a technical way. They might be scientists, they might be economists, and they know a lot about ozone and sulfur oxides and greenhouse gases. And they don't have the power to make policy on their own, even though they are policymakers in some sense. They're subject to their bosses. When I worked for President Obama, I was the boss of many civil servants, and I felt very lucky to be able to work with people who were both so exceptional and so aware of the limited nature, important but limited nature of their own role. I wouldn't worry about them. They, in my experience, I'm sure there are times and places where one should worry about them. I have worked on occasion in a less formal way with civil servants in multiple nations, maybe 10, and a very limited experience, but not none. And I've been impressed and honored to be able to see such extraordinary people and to hear about their work, and they're not making a lot of money.
Thank you very much. And I absolutely meant the worker bee analogy as a term of endearment. I myself have worked for a European administrative state agency, the Fundamental Rights Agency, so I also have respect for those civil servants that work in these fields. I just wanted to clarify that, and thank you for your insights. And along these lines, since we talked about judicial governance in comparison to administrative state, there's an issue with regards to the judiciary that we normally touch upon when we discuss the administrative state, and this is called judicial deference. And my question would be, to what extent goes what we call judicial deference in light of the acts of administrative agencies in the US at this point?
Okay, thank you for that. And this would be a question which I believe would have not the same answer in all nations, but I also will say somewhat recklessly, will have a similar answer in many nations. And here's the answer. If we have a judgment of fact, then the court will defer to the judgment so long as it's not arbitrary. So if an agency says that a certain substance is carcinogenic, if that has evidence behind it and is not arbitrary, the court will defer to it, even if the judge's own opinion is that it's not carcinogenic based on the judge's own reading of the science. So there's deference on factual judgments. Or if an administrator says that if you install certain technology in cars, you will reduce the risk of a crash by a significant amount, even if the judge thinks that's probably wrong, the judge will defer to the administrator. So let's take factual judgments as one where there's some deference, but arbitrariness is not permissible. Now let's suppose there's a policy judgment where the policy judgment is, let's say, that it's a good idea to eliminate some program, where the Biden administration is eliminating a program that the Trump administration liked, or the Trump administration is eliminating a program that the Obama administration liked. There too, the court will defer, meaning it will not think that it's its own role to make the policy judgment, but the policy judgment by the administrative agency cannot be arbitrary. So if one agency changes the view of a previous agency, the same one, it had better say why, it had better investigate alternatives, and it had better explain why it likes its own policy and thinks it's a good idea to have its policy rather than the predecessor. And the court will defer, but if the agency doesn't respond to comments, public comments, if the agency ignores alternatives, if the agency's explanation is illogical or makes no sense, the agency will lose on the ground that it's arbitrary. So the assessment of policy and the assessment of fact are similar, some deference, but not complete. Now let's suppose the agency makes a judgment of law. Let's suppose there's a word in a law, let's call the word harm. And the question is whether if you destroy a habitat that endangered species visit, is that harming a member of an endangered species? Until the last 10 years, the idea was if the law is ambiguous, the agency's interpretation prevails unless it's unreasonable. So the agency could lose, first because the law is clear, and second because the agency has adopted an unreasonable interpretation. But if the law was unclear and its interpretation was reasonable, the agency would prevail. And that gave a lot of authority to President Clinton, President Bush, President Obama, President Trump. The court right now is rethinking that idea. And the idea of deferring to agency judgments on questions of law is less popular now than it has been at any point in the last 30 or 40 years. So the court might say in the next 2 or 3 years, On questions of law, we don't defer. Those are questions for the court.
Thank you very much. I'm in the very fortunate situation that I have witnessed my sister write a book on science and judicial reasoning. And part of her research was done at Harvard, just recently published, Cambridge University Press. So I'm very familiar with the issues that you're talking about. It's a vicious circle. You know, you can't really reconcile science with judicial reasoning and adjudication on many of the issues that we mentioned. And this brings us to almost the end of our talk, and also a practical question to finish with. We've talked about a couple of issues already, but could you give us some examples of past debates in the US that inform thinking about the administrative state? What we hear in Europe is relevant to the so-called diesel scandal that has been uncovered. It has ties to the EPA, or anyone who's familiar with business and human rights is now more and more familiar in Europe as well with what OSHA does. And since you just mentioned the lack of judicial deference on questions of law, the FCC comes to mind, for example, the Federal Communications Commission. And in many cases, these organizations have shaped Supreme Court case law in terms of the First Amendment, for example, if I'm just focusing on the FCC now as an example. So how can these organizations shape thinking about the administrative state through their work? And could you give us some examples again on the past debates in this context to finish with? Thank you very much.
Great, thank you. I'll give you an example from 3 agencies. The first is the Environmental Protection Agency, where a key question for climate change is what is the social cost of carbon, which is what is the monetary value of a ton of carbon emissions? And that's a very important question because it is relevant to the stringency of regulation of automobiles, of power plants, of much more. So is the social cost of carbon €1? Is it 500 euro? The answer is really relevant to regulatory decisions, and a high number will argue for more aggressive regulation than a low number. And this question has hit the courts. It's in the courts now. I'll talk about the past, where the Obama administration chose about 50 euro approximately. And it did that making a decision that if the United States imposes emissions that hurt people in Hungary or China or Germany or France or Mexico, those count. So it's the global damage that's included. And this came to court, and the question was, is it lawful to do that? Is it arbitrary to do that? And one of our lower courts said that's lawful. The Trump administration shifted to say it's only the domestic number that counts, and the lower court struck that down as arbitrary, saying that the Trump administration hadn't adequately explained its choice of the lower number. The Supreme Court has not resolved this. So that's my first case where science and economics come to court after being in the administrative state, where it's a very, very important choice. The second issue involves the FCC, as you say, where the FCC shifted, I think it was under President Bush, to regulate obscenity on air a little bit more than the Clinton administration's FCC had. And the more restrictive approach, the Supreme Court said, we will uphold that. And the reason the Supreme Court said that was twofold. First, it said that the agency has expertise and accountability as we don't. So it's not going to be judicial rule. We're just judges. Second, the court said that it wasn't arbitrary to shift, that if you use a bad word, a child might hear the word, might cause harm. And third, the court said that the agency had adequately explained itself it had considered all the relevant factors and explained why it liked the policy. So that involved the choice of words. Forgive me, you had one other agency you mentioned, and I did have an example from that agency, OSHA?
It was OSHA, yes, yes, yes.
Yeah. Okay, so OSHA, I'll give you a case from a long time ago where OSHA regulated benzene very aggressively in an effort to protect workers. And what OSHA said was, under the law as we interpret it, even if there's a small risk, really small risk, we can regulate it. And the Supreme Court said no, that to regulate a risk that it can't be shown to be significant is unlawful. And what the Supreme Court was basically saying was that under the law as we understand it, you can regulate significant risks, but you can't regulate tiny risks. And the court clearly thought that was a way of preventing arbitrary decisions and also a way of restricting the administrative state from overreaching.
Thank you very much. And in order not to restrict myself from overreaching and monopolizing this conversation, I'm now turning to our audience here. If they have any questions on what we have heard so far, same goes for our online audience as well. So if you have any questions, feel free to ask. And I see
I have a question, if I may. So you mentioned welfare and rule of law. So basically, my question is that which one should precede the other? So if there is a conflict between welfare and rule of law, should the administrative state, at least in the sense that the United States understands administrative state, should they choose welfare or the rule of law?
It's a tough choice. I go with the rule of law, not for philosophical reasons, but because of institutions. So ultimately, the rule of law probably has to be defended on the ground that it promotes human welfare. So philosophically, welfare, on my view, has priority. But in actual practice, did Shakespeare say that way lies madness? So if you have decisions about welfare that aren't cabined by the rule of law, that way lies madness. So for both courts and administrators, treat the rule of law as a solemn obligation that is in the sky, staring at you with hope.
Okay, thank you very much.
Any other questions? We have one here.
Maybe one tiny question.
Can you hear the question? Sorry. Can you hear the question?
Can you hear me speaking?
Very well, as if we were in the same room.
Wow,
Perfect.
thank you. So if you take rule of law as an abstract concept, can you say that it can be developed outside of a state or a nation state or a community and somehow engineered as an abstract concept? Or is it something that is embedded or it's attached to particular nations, to particular communities, and influenced by their histories, cultures, experiences? In other words, rule of law is a unified concept, or it's a concept that varies from state to state? And one more tiny question: can the European Union develop the rule of law in light of your answer?
It's a great question. Thank you. So several decades ago, I was teaching in China, and I talked about the rule of law actually in ways that overlap with the current discussion. And I was teaching administrative law, and I understood the rule of law discussion as a kind of preface to the discussion of administrative law. I didn't understand it as a very fundamental or important part of the course I was teaching. I thought that it was a preface. But my Chinese students thought it was by far the most important part of the course, and they were very fixed on the idea of the rule of law. They almost started to cry when they talked about it. And one of them decided to do a little book. I don't know if it was published. I saw parts of it on the rule of law in Chinese traditions. And the claim was that the idea went way back and did have firm roots in Chinese traditions. That's interesting. I think any nation on the face of the earth will be drawn like a magnet to the idea of the rule of law, whether or not ultimately it subscribes entirely. So in India, there's a rule of law tradition. In Spanish-speaking nations, there's a rule of law tradition. In Japan, there's a rule of law tradition. In Africa, there's a rule of law tradition. So it seems to be something that's part of cultures. The European Commission, I need to think more about it, but offhand, it could deem itself bound by the rule of law in the sense that it won't urge things that are retroactively punitive, in the sense that it will urge things that are general and clear rather than opaque and singling out particular people for punishment. So offhand, the European Commission could, and I hope is, could be, and I hope is committed to the rule of law.
Thank you so much.
Thank you very much. I'm looking at our audience, but no more questions. Maybe just one more to finish off, because we've talked so much about environmental law and adjudication, judicial governance, the administrative state. And then I know that there is an effort in Ireland at this point to introduce specialized environmental courts for strategic litigation cases. Where would these kinds of institutions fall between judicial governance and the administrative state? And do you think that it's a good idea to introduce these specialized courts in a national system?
What a great question. I should say that my wife is Irish and I was married in Ireland. So I tend to think whatever Ireland is doing is probably good, or at least I should say so. It would depend on the context. Many nations have shown an interest in specialized environmental courts, and I think for two reasons. One is that the courts would have technical expertise to deal with questions that require technical expertise, and the other is they might want the judges to have a certain general sympathy with environmental protection, and they might think that the general courts would lack that. I think in the abstract, it's very hard to say whether specialized tribunals are a good idea. It would depend on my favorite thing, costs and benefits. And if the benefit is you get more accurate because more specialized judging, that's good. If the cost is you get less fidelity to law because the judges have a rooting interest, maybe in one or another side, that would be a cost.
Thank you very much. And I'm looking at our audience again, but I don't see no more hands in the air. So Professor, I think we've reached, organically, we've reached the end of our conversation. And I think we've had a very lively conversation about law and Leviathan and the redemption of the administrative state. Thank you very much for sharing your invaluable insight with us. And we hope to see you soon on another occasion. And I'd like to thank you for taking the time to meet with us today.
Thank you. I was in Hungary not long ago, and I hope to visit again soon. And I thank you for your generosity.
Thank you again. Bye-bye.